Assalamualaikum warahmatullahi wabarakatuh. So we are from Group 3, JLB8, presenting the case of Karimah binti Abdul Ghani and 66 others as the appellants and the state government of Kelantan and others as the respondents. So on behalf of the group members, Muhammad Khairul IMRAN bin Khairul ANUAR, Nur AMIRAH ZAHIDAH binti Wan ANUAR, Nur Amalin Husna binti Muhammad NADZIR, and myself, ABDULLAH bin AHMAD YANI. So the first issue regarding for the appellants, whether the appellants are entitled and have the right either in law or in equity, and to compel the respondents to compensate them fairly and fulfill their promises. So the appellants submit that rejecting the claim that they were squatters in illegal occupation of the said land, but temporary occupation license holder TOL that have exclusive possessory hands entitled to the land and have the right in both, which is law and equity. All right. So on behalf of the appellants, we say that the appellants are not squatters and not in illegal occupation of the land. Referring to the case here, which is Buhari bin Taib and others, and Pengarah Tanah Galian Selangor, the court determined that the appellants were entitled to the land and that they were occupants with permission and approval, which is distinct from squatters who have no rights at all. Also, in the case of Bukit Lenang Development Sendirian Berhad and penduduk-penduduk yang menduduki di atas tanah, at Mungkin Pelentung daerah Johor Bahru, according to the High Court, a license or consent to occupy may only be granted by one who is authorized by the law to do so, which is the registered proprietor in whom the right of ownership is vested. All right, so what are the meanings of the squatters actually? A person is in unlawful occupation, which is squatters, and is liable under Section 425 of the National Land Code 1965 if they occupy or erect any building on state land without lawful authority. However, in this situation, the appellants have occupied for temporary occupation license, which means they are not squatters. All right, in the case of Tehbi and K. Maramutu, there is no provision for the TOL to be renewed annually, but there is no obligation on the part of the authorities to grant renewal for any subsequent year. As we all know, the temporary occupation license will renew every year at the end of the calendar for a few limitations and few times. So the appellants are legitimate occupants of the property in this case because the respondents demonstrated their implicit permission by never taking action to remove the appellants in the 48 years after the first time they arrived at the land. How come the state authority claim that the Perbadanan has the right upon the land, although the appellants has stayed on the land for 48 years without giving any notice or giving any instruction to the appellants? So the state authority has also never neglected to renew the TOL on behalf of the appellants, even though they have the authority to do so under Section 67, subsection 3 of the NLC 1965. Furthermore, the appellant secured that the SA, which is state authority's formal clearances, because the TOL is expected to be no more than 3 renewals. It demonstrates that the appellants have implicit agreement from the SA to occupy the land. All right. Rights of a holder for TOL in law. Section 44A of the National Land Code states that a TOL holder that has been granted the land and have the possession to it shall be entitled to the exclusive use and enjoyment of so much of the column of airspace above and the surface of the land, and so much of the land below the surface as is reasonably necessary to the lawful use and enjoyment of the land. We could see the case here. In the case of Muhammad Said and Fatima, the Court of Appeal stated that the TOL provides its holder exclusive possession to the land and the things thereon that covers from the date of issuance to December 31 of the year of issuance. If the license is renewed, it gives exclusively possession to the licensee, since a monetary payment is a condition precedent to the grant of any license or renewal thereof, commenced at the date when the payment is made. Also, in the case of Muhammad and Kunji Mohidin, the toll holder has the exclusive possessory that have the right to maintain an action for ejectment against trespasser. In the instance case, the appellants have obtained the right as a toll holder to have an exclusive possession. Thus, they have the right to evict the respondents that enter the land without any consent. All right, now we come to the rights in equity. As we could see, for 48 years, we could say that there was quite a delay made by the respondents. We could see in the case of TNB and Vijaya Lakshmi, this High Court applied one of the 12 equity maxims, which is delay defeats equity. The term laches is a principle under equity law. That means the court cannot accept an action that takes long time to be filed in court. As we could say, for land law, for any cases regarding on land, it only limited to 12 years only. Therefore, if this is done, it seems as acquisitions for the plaintiff to take action against the defendant. Also, in the case of Abdul Rauf bin Dato Dawood and Dr. Abdul Rahiman bin Dato Daud, the court agreed with the Court of Appeal, and the grounds given for concluding the limitation had said and that the law of laches worked against the plaintiff in this instance. Furthermore, a strong case for laches was presented by the plaintiff when the plaintiff's action was initiated several years later. After all, of the witness to the 1981 agreement had died. For the application, the respondents delayed taking action to urge the appellants to quit the land for 23 years after the alienation and 50 years after the appellants first arrived to the land. In this situation, the principle of laches would be used. As a result, the respondents has no right to the land. All right, compensations from the respondents. Article 13, Clause 2 of the Federal Constitution says, there is no law shall provide for the compulsory acquisition or use of property without adequate compensation. So it shows here that the respondents should give compensation to the appellants before they take out the land. Also, in Section 2A of the Land Acquisition Act 1960, said that if any land is required for public purposes, there are matters to be considered in determining the compensation to provide adequate amount. The first matter to consider is the market value of the land based on Section 2A of the first schedule. Also, in Section 434 of the NLC, states that where under any provision of this act, any person or body is entitled in respect of any matter to compensation to be agreed or determined in accordance with this section. The amount thereof shall be such as may be agreed between him and the state director, or in default of any such agreement determined by arbitration. All right, for the compensation, We could say that in this case, the respondents offer 500 ringgit to 1,000 ringgit in compensation to each appellant's family was insufficient, demonstrating that they never considered any of these before establishing the appropriate sum, which is the appropriate amount. How come a person who has stayed land with certain time, long time, would only give 500 ringgit to 1,000 ringgit only? The appellant's argument demonstrated that there was no agreement between them on the amount of compensation given. A reasonable compensation must be reviewed and determined between the appellants and respondents in order to arrive at a amount that is adequate and agreed by both parties. This shows that supposedly to be the appellants and the respondents should make an agreement regarding on giving the compensation among them, which is need not be subsequent but need to be adequate. So in conclusion, the appellants are entitled to the land, have the right in law and also equity to compel the respondents to compensate them fairly and fulfill their promises. That's all from me. Thank you.
My name is Muhammad IMRAN bin ANUAR. Machine number is 12021886. So I will be presenting on behalf of the appellant. So for the second issue, whether the respondents can go in, turn the appellants out, and even use force against them, should they refuse to vacate the settled area? So the appellants submit that firstly, the respondent cannot go in the land before 2016 as they will be considered as trespassers at the time. Secondly, they should not use force, instead giving notice with reasonable time. Thirdly, the appellants has to vacate the land since the tool license was expired after 2015. So, firstly, the respondents will be considered as trespasser before 2015. According to the section 425, subsection 1 of the National Land Code 1965, any person who unlawfully occupies the land shall be liable to a fine not to exceeding RM 500,000 or to imprisonment for a term not exceeding 5 years or both. So, in the case of Zuleika BB and Maidin, 1961, the plaintiff is a holder of a toll permit. In the statement of the claim, the plaintiff alleged that the defendant had illegally occupied a house on the land and applied to the court for recovery of the property and damages for infringement, cost, and incidental damages. The defendant pleaded that he was in possession of the property. The High Court held that the toll holders have the right to sue for trespass any other individuals who entered the land without authorization during the toll, even if the defendant was the original the toll holder. So, for the application, the appellants were a legal occupier of the land as they have been paying for the toll license without fail until 2015. Also, the appellants were innocent because they were unaware of the alienation land towards the respondents. Within their occupation under toll license, the respondents has no right to order the appellants to vacate the land. Next. Secondly, the respondents shall issue notice with reasonable time. So according to the section 64, subsection 3 of the National Land Code 1965, the proper notice must be published in accordance with section 433. Also, according to the section 5, subsection 2 of the Land Acquisition Act 1960, the person authorized to enter upon any land that is needed by the state authority must first obtain the consent of the occupier, which is the appellant. In the case of public prosecutor against Yaktai, the respondent was a holder of a temporary occupation license of an area of state land in Kuala Lumpur, whereupon she built a house and stayed there for several years. The land was required for a site for government workshops, and a valid notice was served requiring her to vacate the land and demolish the house within 90 days. The respondent refused to comply with the notice to vacate and continue to occupy on the land. So the court held that the respondent would be entitled not only to reasonable notice, but also to a reasonable time in which to remove what she has placed on the land. The in the 90 days given was reasonable. So to apply this case, in the present case, the appellants were unaware about the state alienation land and did not get reasonable notice to vacate the land. So the respondents shall issue reasonable notice with reasonable time uh, in order to they remove their their things as they were occupied there more than 20 years. Therefore, the respondents must not use force, instead giving notice with reasonable time to the appellants. Thirdly, the appellants has to vacate the land since sole license was expired at the end of 2015. This is according to the section 67 of the National Land Code 1965. Toll is issued for a term expiring no later than the end of the calendar year in which it commenced. So now we look into the case Muhammad Said and Fatima, 1962. The applicant obtained toll on 18 December 1956. Then they were not satisfied that their license were terminated on 31st December 1956. The court held that the license expired on 31 December 1956. Thus, the applicant must renew the toll license if he want to continue occupy the land. So to apply this case, there were no facts that the appellants continue the toll license after 2015. Thus, their right to occupy the land was expired since the end of 2015, which is 31st December 2015. Therefore, the appellants has to vacate the land merely because of the expiration of toll license, not because of the respondent's request. That's all from the appellants. Yeah.
So we continue to the part of respondent. I am Amalin Husna. So I will present about first issue. So regarding the first issue, the issue is whether the appellants are entitled and have the right either in law or in equity and to compel the respondents to compensate them fairly and fulfill their promises. So here the respondent submit that the appellants are not entitled and have no rights either in law or in equity to compel the respondent to compensate them fairly and fulfill their promises because they are squatters and have breached the TOL's condition under the National Land Code 1965. For the first sub-issue here is that the appellants are squatters and they had occupied the land illegally. So we refer to the case of Bukit Lenang Development Sendirian Berhad and penduduk-penduduk Mukim Pelentong. Here the court defines the squatters as a person who enters upon another's land and remains thereon to the detriment of the present owner, a trespasser, pure and simple. So in section 48 of the NLC, there is no title to state land shall be acquired by possession, unlawful occupation, or occupation under any license for any period whatsoever. We refer to the case of Siddiq bin Haji Muhammad and others, and the government of the state of Perak and others. So here, in this case, there are unlawful occupiers that have been on the land before the state authority alienates the land to a registered proprietor. Thus, that registered proprietors seek an order of possession from the court to recover possession of the land. The illegal occupiers invoke a defense that several acts and promises by officials of the state, such as the district officer, had given the occupiers positive encouragement that the state authority had in principle consented to their occupation of the said land. So here the court said that the promises by state officials cannot be taken to be an act of the state authority as these state officials are not known under the National Land Code as the state authority. So to apply in this instance case, the appellant are squatters who occupied the land and they are illegal. So even there is blessings and monetary assistance from state exco members and politicians which came and visited them, it does not act as the state authority. Therefore, the appellants had no right to compel the respondent to compensate them fairly. Okay, so we move on to the next sub-issue, which is the appellants have breached the tolls condition under the NLC. So according to section 67, subsection 4 of the National Land Code, every toll shall be in form 4A. So here, the appellants have breached the tolls condition by building houses on the land. In that form, which is form 4A, it provides that this license may not be used for the erection of any permanent building or other permanent structure. Okay, we refer to the case of Papu and Beraya. So in this case, the High Court delivered that if a toll holder decides to build a building on the state land, which he occupies by using the virtue of the license, clearly he takes the risk of losing whatever his belongings that has been put in the buildings. So to apply in this instance case, the appellants have breached the tolls condition by building houses on the land. As in Form 4A, it provides that this license may not be used for the erection of any permanent building or other permanent structure. Okay, we also refer to the case of Tehbi and K. Maramutu. Here, the court provided that in accordance with terms, occurs and conditions which are written in the form of toll may be cancelled immediately, and if the breach occurs, there shall be no payment of compensation. So to apply, the breach had happened, right? So thus, the appellants have no right either in law or in equity and to compel the respondents to compensate them fairly and fulfill their promises. Okay, we go to issue 2. Thank you.
Okay, thank you, Amalin. My name is AMIRAH ZAHIDAH, and I'll be presenting the second issue on behalf of the respondent. Okay, the issue is whether the respondent can go into the said land and turn the appellants out and can use force against the appellants since they refuse to vacate the said land. Okay, in this case, they submit that they can go into the said land and turn the appellants out and use force against the appellants since they refuse to vacate the said land. And the respondents are the legal owners of the land. And also, the respondent can use force to evict the appellants. Next slide. Okay, in the first sub-issue, respondent are the legal owner of the land. Okay, according to the section 341 of the NLC 1965, it provides that this section protects the title of the registered proprietor of land against any claims and adverse possession by squatters. And other than that, section 44 also stated that the owner owns everything up to the sky and descends into the middle of the earth. However, the right to enjoy land is not absolute, but subject to other provisions under the National Land Code 1965. Any other written law and the enjoyment of the land must be reasonable, necessary, and must be valid. Next slide, please. Okay. We also refer in the case of Imetek Sendirian Berhad and Yong Tai Hung and another. Okay, in this case, the plaintiff was the registered owner, whereas the defendants had not established any right, either in law or in equity, to the land except as mere squatters or trespasser, even though they have been occupying the premise for the past 40 years. Improve the land and house, and the occupation was with knowledge of the owner. In another case, which is Siddiq bin Haji Muhammad and others, and Government of Perak and others, the Honourable Court held that the state authority has the power to dispose the squatters at any time. So to be applied in this case, the ownership of the land was transferred to the PKENK, which is Perbadanan Kemajuan Ekonomi Negeri Kelantan, after the alienation in 1990. Next, the state has no longer have the right over the land, because once the land has been alienated to the PKENK, so the person who have been alienated to the land became divisible owner. the state does not need to inform the appellant that the land has been alienated. So in conclusion, the Court of Appeal was right, held that the respondent can take the remedy into their own hands by going in themselves and turn to the appellant out. Next slide, please. Okay, in the second sub-issues, which is the respondent can use force against the appellants. Okay, as been stated in the Regulation 6 subsection 1 and Regulation 7 of the Essential Clearance of Squatters Regulation 1969, this regulation assists in evicting the respondent from the said land if their structures are found to be squatters' huts. Definition of squatter huts have been explained in Regulation 3 of the Essential Clearance of Squatters Regulation 1969. Okay, we refer to the case Datuk Bandar Majlis Bandaraya Shah Alam and another and Yusuf bin Awang and others. In this case, the registered owner of the land seeking assistance from local authority under the Regulation 6 subsection 1 and 7 of the Essential Clearance of Squatters Regulation 1969, which these are the regulations that help expel respondent from the land if their structure is found to be a squatter hut. Next slide, please. Okay, according to the Regulation 4 of the ECSR 1969, this states that local authority may demolish squatters' huts on state land, reserve land, mining and forest. In Shamsuddin bin Chekmat and Datuk Bandar Kuala Lumpur, the statutory powers of the respondent under the Regulation 4 of the ECSR 1969, they are not dependent on any notice. The powers to demolish could be exercised at any time without issuing any notice. We refer to the case of Siddiq bin Haji Muhammad and others and Government of Perak and others. The learned judge observed that the owner is not required to seek a possession order from the courts, as he has the right, if he chooses, to seek out the remedy on his own. To seek out the remedy on his own, he doesn't need the aid of the court. He can walk in and deal them himself. He may even use force if he does not go beyond what is reasonably necessary. Okay, for the application, respondent can follow the Court of Appeal that they can take the remedy into their own hands by going in themselves and turn the appellant out without the aid of the courts of law. And last but not least, the respondent can even use force against the appellant being the squatters as long as it is reasonably necessary. Okay, that's all from me. Thank you.